Good afternoon, everybody. Today I'm going to talk a little bit about contracts. Generally speaking, I see two different aspects of contracts law here in the office. One is the cultural aspect, the other one is the legal aspect. Actually, the cultural aspect, I think a lot of people are afraid to contact a lawyer before entering into a contract because they think they have that feeling that the other party, is going to think they're suspecting something is wrong or not trusting that they're being honest. So there is always this issue, culturally speaking, that, let's not hire an attorney. We're friends or we're business acquaintances, or maybe it's a relative or, somebody like that, and they don't want to break that trust. Unfortunately, that leads to a lot of problems in the future, because what ends up happening is either they pull something out of the internet that's totally incomplete and insufficient. Sometimes it doesn't even address what type of business the parties are entering into. Or one of the parties, not the person that's coming to me, the other side hires an attorney to draft the contract, and my client, at the time didn't hire an attorney to at least review the contract. And that's where we see a lot of problems, because obviously the contract is going to be very unilateral, and it's going to benefit obviously the person that was represented by an attorney. So my recommendation in that sense is, put personal things aside. Even if you know the person you're entering into business with, put that aside. And, even if you don't hire an attorney, at least consult with one so you know what your rights and obligations are. And if you do have the other party's attorney draft the contract, at least hire an attorney to review the contract and make sure that it's balanced and that it's not totally beneficial just to the other side. And that's just what attorneys do. When you're hired, you're going to look for the best interest of your client. So obviously, if the other side is not represented, unfortunately, that person always gets the short end of the stick. It's just the way it is. So I always recommend make sure you're represented and make sure you do your due diligence before entering into a contract. That's also the other side of it, actually the legal side. So let's talk a little bit about the legal side of things. If you're buying a business, for example, make sure you do your due diligence. You can always start with a notice of intent, a letter of intent, and then you have about 20 or 21 days or so. You can be adjusted to do your due diligence. Get the books, get the financials, investigate, make sure that that business is sound, that it's not about to go bankrupt. Don't rush into things. I think a lot of people rush into buying a business, because this is such a good opportunity. Just do your due diligence first and make sure that you're not buying, a money pit. And then the other issue that I see a lot, particularly with contracts that people try to draft themselves, or they pull it out of the internet. They are missing a lot of the most important terms that a contract must have in order for it to be valid, and even enforceable as well as helpful, because that's the whole point of having a contract. So just quickly, because I don't want to go over in detail too much, but just to give you an idea of some of the terms and the clauses that are necessary that I recommend are always in the contract. One of them is basically the duties and obligations of the parties. You need to make sure that all of that is listed there, because if you're not listing what your obligations are and the other side's obligations are, you're going to have a problem eventually. So you need to be detailed. Obviously every contract is different, but you need to have that detailed information, what each party's obligations are, and then consequently to that, you need to have a clause for liabilities, or default for each party. So if this party commits either an act or omits something, either by action or omission, it will be considered a breach. So that needs to be also listed, because what is considered a breach of this contract or this agreement. The other clause that's very important, sometimes people don't include, is the one for attorney's fees, because in Florida, for a contract, in order for you to get attorney's fees, reimbursed attorney's fees from the other side, it's either provided by statute, which is rare, or by contract. So if the clause is not within your contract, there's nothing you can do about it. You're not going to be able to recover your attorney's fees from the other side if the other side is the party that's breaching. So that's a very important clause. The other thing as well is about mediation or arbitration. A lot of the contracts that I see include an arbitration clause, which is not my preference, because an arbitrator, any decision that's made by an arbitrator during arbitration is final. So whatever he decides, it's what's gonna happen with the situation, and then you don't have the right to go before a judge. So I prefer, personally, there's nothing wrong with arbitration. I just don't think it's I don't, in my opinion, it's not as good as a mediation clause, because a mediation clause, you go either pre-suit, before you file the lawsuit, or even during the process, the pendence of the lawsuit, you go to a mediator. Its mediation is more informal, it's not binding. Everything that happens inside a mediation is confidential, so it cannot be shared outside of that setting, not even with the judge. And obviously, if you don't resolve the case in front of the mediator, which is a much more informal setting, you can always go back to the judge. And that gives you the opportunity to do discovery and go through the whole judicial process, which I think is preferable, at least in my opinion. And the other clause also that I don't see and causes a lot of problems is the clause for rescission or termination of the contract. Within how much time of signing the contract you have the right to rescind. What are the terms in order for you to be able to terminate the contract without incurring any penalties, and things of the sort. So this is just a quick summary. It's just really to give you guys an idea of certain issues with contracts. Obviously, there are plenty of different contracts out there, and obviously different opinions, but those are the most important clauses that I think need to be at least in the most basic of the contracts. So if you have any other questions, if you need any information, you can always call me for a consultation. The number is 954-474-7703. And now my information is in the bio. Thank you. Have a great day.